When Muhammad Norman Oliver arrived at the University of Virginia, where he was hired as the Walter M. Seward Professor and Chair of the Department of Family Medicine in the University of Virginia School of Medicine, where at the premier state university medical college, he was said to have founded the disparities in medicine department at that medical college. Stephen T. Kafkaesque, write that name down. Stephen T. Kafkaesque, MD, Dean and Vice President of that medical school, wrote, "Dr. Oliver brings experience, wisdom, and enthusiasm to his new role, and has established a reputation that has earned him respect and admiration at the national level." But consider this statement from the fact that Norman had only served a couple of years as a family physician working with Eskimos in Alaska. Nobody knew him, making this glowing recommendation at least a little suspect for this poster child for disparities in medicine in a pandemic. And Mohammed Norman and the members of ASTHO assure every American that Pfizer, BioNTech, and Moderna vaccines use the same technology, mRNA, and are highly effective at preventing COVID-19 infections, 95 and 94.1% effective respectively, according to their easy-to-read and made convenient for you chart at preventing symptomatic COVID-19 infection occurring at least 7 days after administration of the second dose, compared with Janssen vaccine, which is reported here to be 66.9% effective at preventing moderate to severe COVID-19 infection during at least 14 days after the vaccine administration globally. Now, the test under the CDC, not under the CDC, but the FDA, is to provide a medication that is going to be preventative in some respects, but at least for 2 months. But here we see right here, 7 days and 14 days. In the law, words are very important, and especially when you are a licensed physician in a position of trust, or what is described as being in a fiduciary relationship with others who rely upon your expertise to guide them, especially in times like pandemic that have been historically associated with fear, confusion, and despair. Wonderful times for a terrorist as well. You must be very careful about the words that you say, and in the Commonwealth of Virginia and in many other jurisdictions, a party alleging fraud must prove by clear and convincing evidence, 1, a false representation, like this comparison chart produced by ASTHO, 2, of a material fact, like the claim that these vaccines provide any percentage level of preventative capability against a novel coronavirus. 3, made intentionally and knowingly, because most people, especially doctors, don't accidentally produce convenient and easy to read charts and post them on the internet. 4, with the intent to mislead. 5, reliance by the party misled, or what we call detrimental reliance. And 6, resulting damage to him. Clear and convincing evidence is such proofs as will establish in the trier of fact a firm belief or conviction concerning the allegations that must be established. First of all, if since December 2020 you have been following the EUAs, and we know you have not, you know that the FDA has published an explanation of the emergency use authorization procedure, which can only be used in the case of preventing a disease, just like the use of the Defense Production Act, when that disease is the result of a biological, chemical, nuclear, or radiological agent that is being used in an attack. Bio warfare. And not to address a communicable disease that is being transmitted from person to person. A fact unknown and certainly not emphasized that may have found quite a few voters in detrimental reliance, trying to avoid each other, engaging in social distancing, putting on masks when they're being attacked by terrorists. And the FDA explained very clearly and precisely An emergency use authorization, EUA, is a mechanism to facilitate the availability and use of medical countermeasures. Countermeasures, including vaccines during public health emergencies such as the current COVID-19 pandemic. Under an EUA, FDA may allow the use of unapproved medical products or unapproved uses of approved medical products in an emergency to diagnose, treat, or prevent serious or life-threatening diseases or conditions when certain statutory criteria have been met. Those are those criteria in terms of being signed off by DOD, signed off by DHS, including that there were no adequate, approved, and available alternatives. Taking into consideration input from the FDA, manufacturers decide whether and when to submit an EUA request to FDA. Under the new drug, this is the normal procedure. The new drug application procedure, NDA, as codified in the Code of Federal Regulations, FDA will refuse to approve an application if it fails to satisfy any one of at least 19 considerations. 1, the methods to be used in and the facilities and controls used for the manufacture, processing, packing, or holding of the drug substance or the drug product are inadequate to preserve its identity, strength, quality, purity, stability, and bioavailability. 2, the investigations required do not include adequate tests. 3, the results of the test show that the drug is unsafe. 4, there is insufficient information about the drug to determine whether the product is safe. 5, there is a lack of substantial evidence consisting of adequate and well-controlled investigations. 6, the proposed labeling is false. 7, the NDA contains an untrue statement of material fact. 8, the drug's products proposed labeling does not comply with requirements. 9, the NDA does not contain bioavailability and bioequivalence data. 10, a reason given in a letter refusing to file the NDA. 11, the drug will be manufactured in whole or in part in an establishment that is not registered. 12, the applicant does not permit a properly authorized officer or employee of the Department of Health and Human Services an adequate opportunity to inspect the facilities, controls, and any records. 13, the methods to be used. The methods to be used in and the facilities and controls used for the manufacture, processing, packing, or holding of the drug substance or the drug product do not comply with current good manufacturing practice regulations. 14, the NDA does not contain an explanation of the omission of a report of any investigation. 15, a non-clinical laboratory study that is described in the NDA and that is essential to show that the drug is safe for use under conditions prescribed, recommended, or suggested in its proposed labeling was not conducted in compliance. 16, any clinical investigation involving human subjects described in the NDA subject to the Institutional Review Board regulations was not conducted in compliance. 17, the applicant or contract research organization that conducted a bioavailability or bioequivalence study described in regulations refuses to permit an inspection of the facilities or records. 18, for a new drug, the NDA failed to contain the patent information. 19, the application failed to contain patent certification or statement with respect to each listed patent. And so here is the truth. My name is Major Mike Webb. And by God, I am running for governor of Virginia. I ask every Virginian and every American true to, like the motto of the infantry, follow me, and we shall overcome. Honest. And y'all come back down. Yep.
Won't you teach me the way? Reach out and lead me, guide me and keep me.
This advertisement was authorized by Mike Webb.
Of your care each day, 'cause I am a seeker and you are a keeper. You are a leader. Won't you show me the way? You are a leader. Won't you show me the way?
And y'all come back now. Here.